expect when I'm meeting with the child? How do they do in school? Medically, whether they've had any, historically, whether they've had any significant medical problems, which some people end up telling me, well, she broke her arm when she was 5, to that's when I find out about the ADHD, and I got one kid right now that has oppositional defiant disorder. It runs the gamut as far as what they tell me. Or I have one parent that comes in that tells me about all these diagnoses, and the other parent says, oh no, totally fine, totally fine. And then the third part of my conversation with a parent is I let them lead the conversation more. What do they want me to know? What background do they feel like I need to know? What's been going on? What is the schedule that they're following now for each parent to spend time with the children? And if it's a modification, I pull out that motion to modify that has all of the allegations and walk them through them. Both motions to modify. So I'll walk through their motion to modify first, and what's your basis for this allegation and that one, and then I turn to the other parents and I say, okay, he or she is saying this. Why do you think that she's alleging that? Why do you think she's alleging that? And let them give their background. Once I've met with each parent, with both parents individually, I make the decision of how I'm going to meet with the children. And I do a couple of different things. I have a couple different options. Sometimes I'll just have, at the beginning of the case, I'll have one parent bring the child, and then maybe later the other parent, I'll alternate having them bring them as needed. Sometimes, given the allegations, if there's allegations of alienation or other things, I may set up 2 meetings, one with one parent bringing them and one with the other parent bringing them back to back within a few days or a week of each other, just to see if I just had that happen where the daughter was a completely different person when dad was bringing her versus when mom was bringing her, which was interesting to see. Sometimes, especially with younger children, I'm doing that this afternoon, I'll go to the house. I'll just swing by the house late on in an afternoon and see them, because it's not a situation where I need to talk with them in private. A 3 or 4-year-old is not going to tell me so much that I don't feel like I can't see them in their home. And if there are allegations about the home as well, that's another time I do a home visit. A lot of times with teenagers, I'll go see them actually at school. And my office will figure out when they have a break, lunchtime, study hall, whatever, and go there to meet with them, just so neither parent can say, oh, she said that because mom or dad brought them. And sometimes it's a surprise to mom or dad that I actually went to school to see them, which is nice. So once that beginning part is done, I decide what else I need to do to get all my background information. I talk to therapists, may need to get HIPAA authorizations to do that. I'm always curious to see what I find more often than I like to think about, is therapists are sometimes one of the parents doesn't know that the child is going to a therapist. And what input has that therapist had from the other parent or contact with that other parent? I talk with babysitters, I have grandmas that come in to see me, like I said, past GALs. We get whatever records we need. If there's an IEP at school, I'll get that. Other medical records, depending on the allegations. And then moving towards what the allegations about the parents are. So if there are drug or alcohol allegations, looking at doing a sure test to do those kind of testing on the parents. If we have a parent that acknowledges an alcohol problem, figuring out how to deal with that. Sometimes we'll use SoberLink to have them monitored for a while and see how that goes. Is counseling needed for a child? Is the relationship between the child and one of the parents broken down such that we need someone to work with them? And just figuring out from there, do we need a communication app, our family wizard, talking parents, and those types of things. I find it so interesting. Judge Hilton was talking about allegations. I find it so interesting. I just got my postcard for my 25th law school reunion, save the date, next year. So been doing this about 25 years. When you look back to the mid-90s, late 90s, when I started doing this, it seems like all of my cases have a GAL on it. But we're moving to a point where parents are getting, and I'm going to say fathers are getting more time than they ever did before. It used to be 1996, 1997, alternate the weekends, Friday at 6 to Sunday at 6, and then the debate was, it's Wednesday night for dinner or overnight. That was the argument, that was the discussion. And now we are, parents wanting 50-50, but yet we have more more GALs. We're called on, we've talked about, to manage the litigation more, to manage services for people more, and we do have allegations of abuse, but sometimes we don't. It's just such a volatile relationship, and I just find it so interesting. We have that inverse relationship where both parents are getting closer and closer to equal time, but yet we're getting more and more appointments. Or I'm just, even when I'm representing litigants, we're having GALs, and it's more of a given than not that we're gonna have them. So, the other thing that MJ asked me to talk about was the conflict between doing what's best for the family and what's necessary to prove your case. And I called Jeff last night and said, what the hell does that mean? So, one of the things that I am seeing more and more teenagers becoming defiant in not wanting to see one parent or the other. And what worries me when you talk about what's best for the family versus what's needed to prove your case, sometimes there's no allegation. They just don't want to be with the other parent for whatever reason, and they're coming into court and they're thumbing their nose, and they are testifying, and we're empowering them because you have parents that are parallel parenting and not being supportive of each other, and saying I'm sorry that your mother made you mad, but you're going to go anyway. They just don't do that. And so what I'm finding, though, when there are actual allegations, and it's only the child that can come in and say, this is what's happening to me, that child is going to have to come in. And it may be what's best for that child to come in and testify so that the judge can hear directly from him or her what's going on in that home. But at the same time, what happens if that judge doesn't listen to them? Or what if that empowers that kid so much that it ruins the relationship with the other parent even more? And I think that is where I'm seeing the biggest problem with these teenagers not going cases is, how do you then prove up that case without doing more damage that's already been done? And there's no good answer. There really isn't. And I've seen, they get one kid who was in his hoodie, and a judge in St. Charles took him in his back office. The attorneys were back there, and he was testifying, and he slumped in his chair, and he said he just didn't want to go to Dad's anymore because his dad, he got in a fight over him doing laundry, and Mom just doesn't set up any rules over there. And the judge said, look, I raised boys. You'll be happy one day that your father was trying to set rules and teach you chores and all of that. And yeah, he wouldn't have any of it. And it wasn't helpful, because the judge, he was trying to express something, which may have been just crap, but the judge wasn't having any of it either. So it's a hard rub there. Does anybody have any questions? I feel like yes, Judge Hilton.
So what do you do as the guardian when you're doing your initial parent intake, and you discover when asking your questions surrounding the pleading that the parent didn't even know about the allegations in the petition?
It happens all the time.
How do you handle that ethically, or what do you do? Do you call out the lawyers?
I will call the lawyer and have a conversation with them. And I'm thinking of one now where, my attorney said I just had to put that in there.
Just sign here.
Just sign. Well, and it's like they knew that it was in there, and they'll say, I have been denied my custody time on numerous occasions, and it's like, well, there were 2 times, and her dad was having a birthday, and so she said, I'm keeping him for 3 hours, then I'll bring him over later, and there was something else that was like that. I'm like, that's not really denying your time going to Grandpa's birthday, And so I see sometimes that either something is in there that they aren't aware of, or something is so exaggerated because they needed to get to that level, and it doesn't help them. There's a lot of times we talk about, you file something with the hope that you're going to get something, and so that's kind of how I look at those, is that this got filed, this got thrown in to get it to a point where maybe we could get something out of it. And yeah, it's difficult because they've made a mountain out of a molehill, and now they're going to have to take their lumps, because the other side, I've got one right now, not in St. Louis County, where the mom filed a motion to modify legal custody because dad wouldn't agree with braces. And she's sending the man email after email after email, just like she does to me. I'm like, now I understand why you don't respond to her. It's over and over and over again, this litany of information, and he didn't respond, and so she filed, her thought was, I'm gonna file a motion to modify and get sole legal. Well, it turns out he files a counter motion, and she's terrorizing these girls. She's terrorizing them. They are scared to death of her, and she wasn't expecting that, and now she's gonna have to take her lump. She made a big deal out of braces, and now She's probably gonna lose some custody time, but, yeah, it is, it's a hard rub, and I'll call the attorney and say, you know, before you go down this road, are you sure you wanna go down it? And, yeah.
Along those lines, are you finding they don't know the definition of sole legal and sole physical?
Oh, absolutely.
I find that happens all the time.
All the time, all the time.
They've applied for sole, and they don't know what that means.
And they're like, well, I'd like to just kind of change the schedule a little bit. And I'm like, well, that's not what you say here. And I think that's, you know, and you and I represent people in addition to doing GL work. I mean, you know, that's part of our job, is to make sure that our clients are understanding what we're filing and that they support what we're filing, and because they're the ones that are signing it and are sworn. Yes.
Judge Hilton touched on this as well. I struggle as an attorney for a party with the concept of letting the GAL have access to the child's therapist. I understand wanting to protect their relationship, and then when we give it to the GAL and not to anybody else, and it's information that of course everyone wants to have, and no one wants to touch it. That's a piece that, for me, what's best for the child and what's best to prove your case really is a struggle.
It is a struggle, and it's, as the guardian ad litem, I have several cases right now where the kid saw me, and knowing what was going on, we put this child in therapy, a combination of child seeing an individual therapist and child seeing someone with Dan. And, you know, mom keeps saying, but I want to bring him back to see you, but I want to bring him back to see you. It's like, well, how many people should be talking to this kid? How many appointments, and how much, do you want to focus on all this? And so I rely on the therapist, and it's not to say that I won't see the child from time to time, but I really rely on the therapist for that ongoing information and how that relationship is improving or making progress, whichever way that's good or bad progress. So yeah, it is. But I think the most harmful thing is for that therapist, like Lisa was talking about earlier, is that therapist having to come into court. Because at least, the child understands that they've got the guardian ad litem. They know me, and they know that I'm talking to that person. I'll tell the child, and I'm going to touch base with the therapist from time to time to try to bring that person into court is just so destructive.
I have one.
But also, go ahead.
I have one even better for you. Full-blown custody evaluation, disseminated to the attorneys and their clients. All that collateral source information is available. And you get one of the litigants who's obviously not happy with the report is now stalking every collateral source, putting it on people's windshields. As a practitioner, do you think you have an obligation to the court to ask that be sealed?
Well, and
I mean, if you know that your potential client has got some mental health issues, that you're concerned about the safety of others, do you have an ethical obligation to file a motion and ask that report be sealed?
Well, in our standard psych eval order talks about how the parties and their counsel are prohibited from sharing information with the kids, and that they're prohibited from sharing information with anybody else other than those, helping with the litigation, expert witnesses and whatnot. But I've had several orders that have been entered in the last month or two where one attorney or the other, or one of them I actually asked that we include in there that the parties can review the evaluation report at their attorney's office, but can't take a copy electronically or a hard copy with them. Of course, then it's part of their client file. So
Yep.
You fire that attorney, you get a copy, there you go. And it is, it's very, it can be a little scary.
Okay. Jeff, you're up.
All right.
The other thing I wanted to talk about just briefly, I know Brian and Mark, Elaine, I think Kim was even involved. Remember when we went through all that stuff with the GAL standards? When's the last time you read those? Okay? I mean, they're still in full force and effect. And it's like anything else. We all have great ideas, and we all implement things and do them all the time. I can't tell you the last time I got a certificate of compliance filed at the conclusion of a case by a GAL. And also, I mean, the standard 4.0 basically gives the court guidance on how to handle motions to disqualify GALs for cause. And if there's no finding there, that's the way I interpret the standard. But so if you're a GAL and you get hit with one of these, take a look at our standards. Wait a minute, I did this. Done. Okay. Sorry, I popped into my head. It's my sometimers. Sorry, Jeff.
No, it's all right. My topic is about discoverability of the GAL file and all the work that we've done and things along those lines. This is open, so feel free to throw something out there, because I really think there's not a lot of law on it, so it's really more of an open discussion. This is premised upon something that happened 4 or 5 months ago, where a GAL got hit with a subpoena for his entire file, his emails, and his texts to the other counsel. And amongst the GALs that do a lot
It's a
of
witch hunt.
Huh?
Oh, sorry.
Yeah, right. It was a witch hunt, yes. And amongst a lot of GALs, it became a sticking point for us, and there was a lot of people that got very ticked off about the idea of revealing our file, and the ramifications of it is we're never going to take notes, we're never going to email, we're never going to do the job we need to do for fear that somehow later it's going to be discoverable. I would give this portion to the litigant, to the trial lawyers, more than the GALs, but I'm saying it to you all so that you have sort of a defense. My question to them is a legal question. Can you get it? The better question is, should you? The better question is, why are you doing that? When in this particular case, this lawyer's client was of the belief that the GAL was in cahoots with the other lawyer, with mom's lawyer. Now, mind you, there was a custody eval, and the GAL was following the recommendation of the custody evaluation. So it was pretty straightforward. But for whatever reason, the lawyer didn't get control of the situation, allowed himself to be sucked in by his client to make the excuse of somehow you're friends with that other lawyer. And of course, it happens because a lot of us are friends. We talk in court, and we don't even realize that the parents are watching us talk. So I'm a GAL, and I'm talking to someone who's representing mom or dad, and we're talking about the weekend, we're talking about things, and now they think we're best friends. So you really have to be very careful. You were talking about that earlier, about you just happen to be talking about the weekend, you're talking about things, and parents can misconstrue it. In this particular situation, they wanted to see all of the GAL's texts and emails. If it was me, I would have thrown my phone at the lawyer and said, here, go for it, and never ever asked me to be a GAL again, because I found it very, very offensive. You're basically calling me unethical. As it turns out, what they ended up doing is they got a special master to come in and take a look at the emails and take a look at it, and as it turns out, that lawyer who was making the allegations had more communications via text and email than the other side did. And of course, those then had to be disclosed. Later in that case, because dad wasn't satisfied, the GAL gets another subpoena to have to now come in and testify. So there's some case law in point, but what I want to stress to you all when people are talking about it, it's not a matter of whether or not you can do it. Why are you doing it? Should you do it? Should you call a GAL to testify? I've been called to testify, and I get up on the stand and I basically summarize my entire case. It doesn't usually go well for the person doing it. So when you get to the point where people are asking that, I think you got to really say, why are you really doing this? Is it just to make your client happy? Because that is going to backfire almost every single time, as it did in that case. So keep that in mind as we go along, is whether or not you should do it, not whether or not you can do it. There are 2 cases that I did recently that got handed out with you all, and I want to tell you about them. One of them actually came down September 17th, 2019. This is Duesenberg versus Duesenberg, and it's about GAL immunity. And it does a very good job of summarizing what our role is and some of how we are considered. And fundamentally, it says that GALs are agents of the court in a quasi-judicial capacity, and that in that regard, we have immunity just like the court does. And it's a very good case, summarizes a lot of it, so I think that's a very important one to put in your research, because it basically gives us immunity, provided that the things we are doing are within the scope and role of a guardian ad litem. So the fact that you are interviewing the kids and you might have said something that dad or mom doesn't like, you made reference to drinking, have you seen the parents drinking, things of that nature. When you get into all that, the parents get very mad that you go there, but it's within the scope of what you're doing, and therefore you have immunity. So that just came out last week, and I really wanted that to come out. And the other case is the Robinson case. This is a 2003 case, and this is directly related to what I was just talking about, and this is the GAL being called to testify. This case actually says may, not can, shall, should. This says the judge may allow it. And I think it's very important that we make note that a lot of times all the judges in the party, they think that it's an automatic, that we can be cross-examined, and Your Honor, I like your idea. Give a closing statement. Then you're not subject to anything after that. Or submit your parenting plan beforehand. I like both of those ideas. Those are great ideas. But if you get called to testify, you need to bring this case up. This case is not to be so that they can rip you apart and cross-examine you as to why you came across it. This case basically stems upon, do you have any factual testimony? Do you know something that was factual in nature? If it's just you gave your recommendation and they don't like it and they want to cross-examine, they're not allowed to. The court can say no, and this is a very good case where the court, it says, the court did not request testimony from the guardian ad litem. The statute indicates that it is within the court's discretion as to whether to receive testimony from the guardian ad litem if the guardian ad litem possesses pertinent factual testimony, and one of the parties shows a need to present such testimony. I don't know when that circumstances is going to come up, because more likely than not, it's not going to be good factual information that the GAL is going to be giving out anyhow. You're only going to put a GA up there for purposes of cross-examining because you don't like it. Why would you give that person a platform? The case I had, I got up there, I summarized one after another until finally Judge Duker said to the attorney, have you had enough? Stop. You're getting killed by this, because it just opens the door for me to summarize my case. I think GALs do have to be more aggressive and not standoffish when it comes to that. When we say, why do you want me to testify? What is it you're looking for? Is there anything factual? We say all the time, here's my recommendation, subject to trial, subject to what evidence is produced at that time. So that way we always have the ability to change our recommendation based on the evidence adduced. In my humble opinion, they should never call you to testify. I don't think it benefits anyone, and if anything, the person who wants you to testify is going to get creamed. And I think it's your job to say, do you really want me to do this? This isn't going to go well for me.
Is that Robinson v. Robinson?
Yeah, it's one of the handouts. It's 128 Southwest 3rd, 543. It's a Western District case. We use it a lot nowadays. Now that a lot of us have seen some of these issues. And I hate to say it, but what I'm finding is a lot of the younger lawyers who are trying to, fight to the bitter end aren't realizing that what you do today affects you tomorrow. What you decide to fight on this case isn't going to get you anywhere, except tomorrow there's going to be a lot of GALs talking about you. I would probably guess 50% of the GALs in this room know the attorney that did that subpoenaed the file, subpoenaed the phone records. Yep.
Jeff, sorry to interrupt. Was there a motion for protective order filed by the guardian?
There was.
And the trial court denied it?
Well, early on, there was a lot of that about to be argued. And very quickly, some of the other GALs got involved, and we kind of called around, and we worked it out to get the special master before that actually got addressed. Okay. So the special master was going to then submit a report. Here are the 3 emails and the 4 texts, and submit those. So some of those motions, there were several motions filed, motion to quash, protective order, they kind of went wayside.
Okay, so it never got ruled on?
They never got ruled on because they were withdrawn once we ended up working it out with the special master.
Gotcha.
So that's, but now, then he did have to testify.
Really?
He did have to testify, yes.
And who got excluded from the courtroom?
Oh, yes, yeah. As it turns out, there happened to be a few disgruntled GALs, about 30 of us. And we showed up in our freedom to be able to show up in any open court, and we were asked to be removed from the court.
Won't get many appointments out of that division anymore.
Yeah, it did not go well. Yes.
So I have a question. I'm thinking of a different time when I would want to ask questions of a GAL. So GAL gives a recommendation, and it actually is in your favor, but you know that they investigated some things that they haven't really said, and you want that, like, they've had conversations or they've seen things that other people haven't seen. In those sort of situations, would you still say ask a couple of questions just to where did that come from? Because you know that they've seen things that are really damning, but they haven't been said in
Well,
court.
you're actually at two different things.
Yeah.
If I've seen it,
Mhm.
I'm a factual witness.
Okay.
And then probably you do have to call me to testify if I've seen it. If there's something that I witnessed, and now I'm the only person that can present that evidence. But if it's somebody I interviewed, you need to call that person. If it's the therapist, we don't like therapists testifying either, but whoever it may be, you got the best evidence and you got hearsay problems.
Right.
So, and GALs are not supposed to base their recommendation at the end of trial on anything that was not produced at trial. So anything I may or may not know that, I interviewed the principal. The principal didn't call to testify. I'm not relying on what the principal told me.
Right.
Because then that's hearsay. That person should have been called. Now, again, going back to what the judge said, and I'll get into this in a second, I do agree that that it is our job to make sure the right case gets presented, and sometimes we have to do that job. I usually start with, I make it clear to the moms, the dads, and the lawyers, it's your job to tell me what's important in the case. I have a checklist that I handed out, that's my checklist that I give out in my beginning interviews, and it talks about, if you have anybody you want me to interview, you gotta let me know who that is. I can't read your mind. I'm not spying on you. I'm not tapping your phones. I always say, I'm not your judge. You have the right to disagree with me. And my next line is, I'm also not a police officer. I'm not spying on you. I'm not tapping your phones. I'm not looking in your windows. I'm not living with you. And I said, look, it's not a perfect world. It's not a perfect system. If I had lived with you for the 10 years and watched all the things he or she has done, maybe it'd be different. I can only rely on the things that you can get to me. But I agree, if you've got some weak counsel going on, sometimes you have to go get it yourself. I do agree with that, but I do start with the burden of bring it to me. So, confidential, oh yes.
I had a question. I was looking at your checklist.
Yeah.
And I know there's a lot of disagreement in this circuit about fees in terms of a lot of times people will say, can I see your fee bill? And, I keep pretty detailed time and I might say, talk to mom or talk to his counselor or did this. What is your opinion or Cynthia or John Hilton about, as GAL, should we be disseminating that? Do you think the litigants have a right to it? Or do we just send them the invoice? Or what's your preferred?
I'll start and then I'll ask both of you your thought on it. I think it's absolutely the only thing that is discoverable. I think it's your bill. I think you have to submit it, and I think it's part of the file, part of the case, and I think you do. That having been said, I don't submit monthly bills. I don't submit itemized bill because while the case is pending, oh my God, they're going to analyze every single thing. Oh, you spent 2 hours with dad, only an hour and a half with mom. I need another half an hour. It's not fair. So during the case, I'm not submitting it. And if somebody wants it, I always say my golden rule is if somebody wants something from me, then I'm not going to go see the judge. Go see the judge if you want something. But I think the bill is discoverable. I usually will go then to the judge. First of all, I'll review my bill. My bill is very met with mom. It is not met with mom to discuss why dad's an alcoholic. Right? It's very, very enough to show the work that I did, but not detailed to say anything specific to make anybody freak out. Sometimes I'll say, interview with witness so-and-so, and I'll put who it is so I know who it was. And I have gone to the judge and I said, I would like to redact some of the names. I've had several cases where the parents, mom or dad, is speaking poorly about them. And they say, I don't want my daughter to know what I'm saying. And I usually, if it does happen, my golden rule is I'm not giving anything. Nothing. If you want anything, take it up with the judge. And if the judge says produce it, I believe that the only thing that is producible is your bill. And I do think you have the right to ask that it be redacted. And And I do think that it should be redacted. I'm sure there might be some that disagree with that, but I think probably that's the only thing that I think is discoverable. Judge, if I came to you, what would your position be on that?
Yeah, I think part of your bill is privileged, so I would support you redacting the information from your time records that would divulge, something you thought was relevant to your representation, the best interest of the child. So I don't have a problem with any of this.
Yeah.
So, I wish I was the judge that it came to.
So do a lot of us.
But I agree, it is discoverable, and that does subject you to examination if you testify and identify it and all that sort of stuff, and then you're opening up yourself for a can of worms, in my opinion. So that's why, I try to protect jails. Go ahead, submit your fee exhibit, submit your parenting plan. That's it. Because, basically we're all officers of the court. I'm the one that determines whether or not it's reasonable or not. But you know how it goes. You'll get cross-examined for an hour and a half about how much your bill is.
Yeah, I will tell you, one of the things that I ask of a judge, and usually I say it in front of the judge with both counsel there, I say, Your Honor, do you want an itemized billing statement, or do you want a summation of amount billed, mom paid this, dad paid this, remaining balance? Usually, most of the time, I get just do a summary. And then my actual bill isn't even needed to be redacted, it's just submitted as a summation of the GAL fees, unless one of these two want to say they want to challenge the billing that I have. Most lawyers are smart enough not to do that, but that's the only time that I actually produce the bill. What do you do?
For each settlement conference, I figure out how much I've charged today and what I'm owed, usually owed, and how much more I need. And then at trial, I do bring my full fee bill. I put very little, Elaine, description. Talk to possible witness, talk to, especially if it's one that is going to cause problems if the actual name is on there. I just put witness. I talk to attorney A about status, talk to attorney B about status. I try to leave it very vanilla that way.
Yeah, see, I very seldom got any, deposit more than $250. when I was doing the GAL stuff, you heavy hitter GAL stuff, at least we're up to 500. But I would periodically file a motion with my bill attached for seeking additional interim GAL fees. I think the bench is better about protecting JLs now than they used to be.
Agreed.
You end up going to trial with a $3,000 outstanding balance, and you know how difficult it is to collect. I mean, I took the bench, and I think I had $500,000 in GAL judgments uncollected. So.
Your retirement plan.
Yeah, Jimmy Fendelman.
Jimmy Fendelman.
Jimmy Fendelman's
Everybody
plan.
loves Jimmy Fendelman.
But I mean, because I didn't do it for that. But I mean, when you have judgments in that amount, my wife said, "What? Why haven't you ever?" No.
It's when the
I'm a
title.
GAL,
It's when the
not a
title.
collection.
That's right.
It's
That's
when the
right.
title company
I wasn't
calls.
doing it for that.
Yeah. Now, I don't have a problem, and this is not exactly on point, but you made reference to billing rate and getting paid a certain amount. I personally don't have a problem with a sliding scale GAL rate. I get appointed on some very, very high conflict cases. The attorneys are billing $4.50 an hour, and we're going to have, in one case I had 21 days of testimony. And so I bill $3.25 on the more difficult, more extreme cases. But there are also cases where you or one of the other judges would say, there's not going to be any money on this case.
Right.
And I say, I understand, and I understand. And then there's a sliding scale. I don't personally have a problem with that. I see
I do the same.
You do the same, yeah.
The more you aggravate me, the more it's.
Yeah, right. Suddenly my rates go up. Yeah, Seth.
So we're talking about fees, and this is a little off topic, but since I'm the only person here, I think, or one of the ones that does bankruptcy, guardian ad litem fees are not dischargeable in bankruptcy. You going to collect them does not violate the automatic stay. If you have questions, I do it for Cynthia a lot. Feel free to call me. But those, I hear a lot of guardians, well, I can't get that fee because it's bankruptcy. There's case law on it. It's not. Please don't just give up on your fees because someone filed.
And that changed, what, 4 or 5 years ago, I think?
Actually, no, it's always been that way. What happened in '05, they changed the code to make it a little more clear.
Okay.
but.
I knew there was something.
Right.
Yeah.
Now, we got a chapter 13, we have to file proof of claim.
Right.
Chapter 7, you don't.
No.
If you hire Jimmy Fendelman, you don't have to worry about it.
It's a Sarah Pleadman
He
case.
just takes care of it all. I want to talk about confidentiality of the things in your file, and there's a lot of therapists here, so I think this is sort of important with them being here. I want their input on this as well. So raise your hand if you disagree or you got additional thoughts. First, let me talk about your discussions with the parents. You don't have technically any kind of confidentiality with them, but I believe your notes are work product. And I believe probably most judges in 2019 are going to agree that it's work product, Your Honor.
Yes.
I think maybe many years ago that might have been not the view, but I think your notes, your communications, those are generally work product. That's how you're going to get around that piece. But you don't have any kind of confidentiality. There are times where a mom or dad would send me an email Monday morning, you're not going to believe what happened yesterday. And they give this long story, and I just want to get the other side of that. And so I might cut and paste pieces of it or summarize it, send it to the other parent and say, tell me your version of this. So that's not necessarily a protected discussion. Discussions with your clients, the children. I don't think there's any judge in 100 years that would disagree that that's confidential, work product, whatever you want to call it. No judge is going to make you divulge that.
No, I wouldn't go that far.
Really?
Never say never.
You never say never, okay. Witnesses, again, I don't think your discussions with any third-party witnesses that are not experts or therapists in the case, I think arguably your notes are not discoverable, but the fact that you did it is, because it's going to show up on your bill. So I think that part of it, there is some form of the party can find out that you did do it. So I do think that's out there. Getting with your conversations with the therapist. I think everybody agrees that the GAL needs to be able to talk to the treating therapists, especially your clients. You definitely need to be able to have that. For the most part, I would think therapists are getting releases. I think they probably, the smart therapists are going to get any kind of release that says, give me permission to talk to the GAL. If that is a problem, and I usually, many of you I know here today, usually as a benefit to them, I'll get it in a court order. So if I have it in a court order, it makes it a little bit easier that the GAL shall have the authority to speak with the therapist regardless of whether or not they got a release. So that, and then I send that to the therapist.
Yeah, but you've just told us we can't tell you things because you can be subpoenaed or testify and so forth.
I think what you're missing, you're right, I can possibly, but I think the context of what I'm going to be testifying to, I can object to at that time. Whether or not I can be called is different than whether or not I can talk about that particular topic. I believe that when I get called, if I have to talk about what I say about a therapist, I think I can object myself as the GAL, and I can say, Your Honor, that's a therapist, they have their own confidentiality, they signed releases, or they did this. I think I can get around it, but a lawyer could...
You know the kind of report that I would write for you.
Yeah.
And it seems to me, you're saying that can't be...
Never say can't. I think the GAL, the judges in 2019 are going to do everything in their power to make that not disclosed in any way. If somebody really wanted to take it up. I mean, one of the things on this other case I was telling you about, there was a lot of people that didn't want to try to work it out, special master. They wanted to have the fight. Several GALs wanted to get into it. And my answer was, whoa, we may not like that. If that gets decided the wrong way, or should go to the Court of Appeals, we then our hands are going to get tied where I'm not going to take any notes. I'm not going to text a lawyer. I'm not going to email. Everything is going to be pretty much a pleading or a letter. And that's not in the best interest of my clients, the kids. It is never, I need to be able to feel very, very good about talking to you, the therapist, and saying, tell me what's going on. And I will do, and I think most good GALs are going to do everything in their power to make sure that is never disseminated. I do think what the judge commented on was very true, that the problem is going to be if there's a psych eval, custody eval, and then it comes out that way. The other thing that I've had happen sort of post-litigation, I have had a 18-year-old child call me and say, you were my lawyer, I want the file. I have also, the month before that, before he turned 18, had his father call me and demand the file. So I know what was going on here. This was the dad very unhappy with my recommendation from 2 years prior, and he wanted to see my entire file. I say the whole thing from beginning to end. Take it up with the court. I'm not turning over anything. I'm not turning anything unless a judge is going to tell me to turn it over. And I think in general, under the massively large umbrella of best interest of the child, I think most judges are going to err on, no, your file is not going to be disclosed. I think that the global idea is to not put the children in a position where their parents know things about them through their therapists, through interviews, through their meeting with me. Any of those scenarios are not in the children's best interest. And I think that umbrella is enormous. And I think we can use that umbrella to cover pretty much all of our problems. Any questions on any of that? Yeah.
You need to be concerned about secondary release of HIPAA qualified materials too. If you give a report to Jeff, he can't release that. He can't use it as a secondary release. He doesn't have the authority to let anybody else go through that. Keep that in mind, because that happens with hospitals. Well, you know, they've got the hospital record from a doctor, boom. And so you've got to be very careful, because that HIPAA release is to him. And he's got to get a further release if he's going to release it to anybody, and that includes an open court.
Well, but for instance, with Rick here, if I give a report to Rick and he's giving a report to the court, it's discoverable that way.
He's not going to give that report.
Well, he may not. This guy.
If Rick Scott is doing, I'm just because we're on the
Well,
microphone.
if Rick Scott testifies, he can do that. He's got a release.
And my release actually says,
Yes.
if I'm doing this for the court,
Right.
what I get is subject to release, so I've already cleared that
He's
corner.
cleared that path for secondary release.
If it's known.
Right.
Any questions? Besides, there is no absolute answer. I think for the most part, if you're a new GAL, I think the best answer is ask an old GAL. That's the best answer.
I know we're over time. Thank you so much, everyone, for coming. If you have any questions, let us know. It's a good topic to get you to sleep.
I know.
It's a good topic.
Talk for 10 more hours if you let me.